Hi guys, welcome to my YouTube channel. In this video, today we will talk about wealth preservation and asset protection. After working hard to create wealth, to provide comfort and security to yourself and your loved ones, the last thing anyone would want to happen is to potentially put that wealth at risk. People are often at a loss as to what steps they can take to preserve and protect the wealth and assets that they have built up over their lifetime. The McCarthy-Weidler team is here to help you mitigate your risks and create an action plan for your future. We can help you through wealth preservation and asset protection planning. What is asset protection planning? In general, asset protection planning organizes a person's assets and affairs in a manner to make them less vulnerable to the claims of unanticipated creditors, and is best initiated before it is needed. You cannot start an asset protection plan after a creditor appears. One popular and effective form of asset protection is asset protection trusts. Asset protection trusts. What is an asset protection trust? Under a normal trust arrangement, the person establishing the trust, the settlor, transfers property to a third party, the trustee, who holds, administers, and distributes the property to designated individuals, the beneficiaries, in accordance with the directions set forth in the trust document. Traditionally, a creditor of the trust settlor could reach trust property if the settlor was also a beneficiary of his or her trust, even if the trust was irrevocable. Under the Asset Protection Trust arrangement, certain domestic jurisdictions, such as Alaska, Delaware, and Nevada, and offshore jurisdictions, such as Nevis, Cook Islands, and New Zealand, allow the settlor to be a discretionary beneficiary of the trust, hold other limited powers, and protect assets from unanticipated creditors. Domestic trust versus offshore trust. Most practitioners will agree that an offshore asset protection trust provides more protection than a domestic trust, especially if the settlor does not reside in the asset protection trust state. If the settlor does not reside in an asset protection state, or has another, non-asset protection purpose that requires a domestic jurisdiction, the settlor should choose an offshore jurisdiction for the following reasons. 1. With an offshore trust, a foreign court will not honor judgments from U.S. courts. Similarly, a foreign trustee will ignore a U.S. court order or judgment. Meanwhile, the U.S. trustee of a domestic asset protection trust could be ordered by a judge to turn over trust property or face contempt charges. 2. With an offshore trust, a creditor obtaining a judgment in the U.S. would need to relitigate the case in its entirety in the foreign jurisdiction. 3. Offshore jurisdictions present geographic, procedural, and financial hurdles to a creditor interested in reaching trust assets. The mere fact that a trust is a foreign trust may deter creditors from pursuing claims or encourage settlement for a fraction of the claim. 4. With a domestic trust, the full faith and credit clause of the Constitution requires states to honor judgments awarded in other states. Thus, a state court may choose to honor a judgment for money against a domestic asset protection trust's assets. 5. With a domestic trust, the Federal Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 added the provision to the Bankruptcy Code that will deem a transfer to a self-settled trust or similar device to be a fraudulent transfer if made within 10 years of filing a petition for bankruptcy, and made with fraudulent intent to hinder, delay, or defraud existing or future creditors. 6. Although subject to the issues described above, a domestic asset protection trust can be drafted to increase the asset protection component by employing techniques such as not adding the settlor as beneficiary until such time when the risk of a claim is passed, or incorporating flight clauses that cause the trust to move offshore if the risk of a claim arises. A domestic asset protection trust has some advantages over an offshore asset protection trust, such as the following. 1. A domestic asset protection trust situated in a state that has low or no income tax can be structured to save on state income taxes of the settlor's home state. An offshore asset protection trust does not offer the same flexibility in income tax planning. 2. A domestic asset protection trust has no special IRS disclosure requirements, making administration easier and less costly. The settlor of an offshore asset protection trust must also choose whether to transfer the trust property offshore. Better asset protection is achieved by transferring property offshore because jurisdictional ties to U.S. federal and state courts are severed, and the creditor must travel to the foreign jurisdiction, where the likelihood of success is more remote and clearly more expensive. Exporting assets also prevents a U.S. court from exercising in rem jurisdiction over the assets, such as freezing a bank. Limited liability business entities. When setting up your business, it is best to get legal advice to determine what type of business entity would best suit you. A limited liability business is great because the partners in the business would have limited personal exposure to any potential liability issues that may arise. This helps to isolate risk, and you would be able to take advantage of state law protections in regard to the debts incurred by a company. Also, if you have real estate assets, whether that be commercial or rental real estate, setting up an LLC, limited liability company, may be an option. Many people who own multiple real estate assets keep those assets in their own name. This could pose a potential risk with liability. Creditor protection planning. Our team can work with you to create a plan to protect against any potential creditor action. If you own a business, medical practice, or professional services company, you may require these types of services. We can put together an action plan to protect you from future creditors. We would discuss estate and financial planning strategies that would help insulate your assets from creditors for current and future generations. We can integrate this plan with a business succession plan and estate plan. McCarthy Weidler has many strategies we can employ to ensure your assets are protected, so that the wealth and assets you worked so hard to accumulate can continue to be enjoyed by yourself and your heirs. We understand that no two situations are completely alike, so we can tailor a plan to suit your specific situation. What do you think of our video? Let me know in the comments section below. Before you go, please hit the like button and subscribe to my channel. Thanks for watching.